Welcome to Little Talks, your weekly dose of marketing news, trends, and insights from Littlefield Agency. Grab your coffee, turn up the volume, and let's get into it.
All right. Welcome back to another edition of Little Talks with Littlefield Agency. Golly, I've got a guest on the line. I'm screwing this up.
We'll fix it in post.
Oh my gosh, we'll fix it in post. Little Talks with Littlefield Agency with a very, very special virtual guest, Sharon Toerek. Sharon, welcome.
Thanks for having me, gentlemen.
Oh my gosh, it is so good to see you, and it's so good to have you on our pod. I'm gonna give you your formal introduction here in a little bit, but I want to give our listeners some background. Sharon and I go back almost a decade now. I think about 9.5 years. As many of you of the listeners know, I'm chairman of Magnet Global, and it's independently owned advertising agencies across the United States, EMEA, APAC, and South America. And Sharon, I forget which meeting it was, but we met and we corresponded, and you were very involved with Magnet at the time. And our paths crossed there, and then boom, in this small world that we live in, you and I quite literally bump into each other in New York City in the World Trade Center.
Technically, it was, a literal physical bump in at a staircase. Right?
I know. I almost knocked your coffee over. I was like, oh my gosh. I was like, I haven't seen you since probably before the pandemic, and we were at Mirren Live together. Thank you to Brent Hodgins for hosting that.
Yeah, I'm really short, so I'm easy to miss.
And no, it's perfect. See, we're opposites, right? I'm nice and tall. We saw each other. We bumped into each other. And here's the funny thing: we were like, "Gosh, we need to catch up." And then life got busy, and then I have a random email from someone, and I believe her name is Chloe, and she says, "Hi, you have Little Talks with Littlefield Agency, and I have the perfect guest for you, and her name is Sharon Toerek." I was like, "Oh my God!" So, Sharon, be honest. Did you bump them, or was this just a small, crazy world?
Total serendipity that I run into you right before Chloe, who
yes.
does give us a little bit of help in scouting the right opportunities. But no, she had no reason to connect dots, and neither did I until she reached out.
No, it's crazy. So I
mentioned your show, so it was meant to be.
I saw your name in my subject line. It is meant to be. I said, Chloe said, "Hey, Chloe, guess what? She's on the podcast," because I already know Sharon. We go way back, and Roop. This is obviously we had a pre-call before this, but you get to hang out with Sharon, myself, and Claude today.
And I'm Roop, the co-host of this podcast that he usually introduces. He didn't introduce me today. I see exactly how this episode's about to go. Hi, Sharon.
I'm not sure whether that means I feel special.
You're special.
You should feel very special, Sharon. Yes, and so and in the nature of being special, I want to give this is a great bio. And here's what I love about Sharon. She gave us a short, and she gave us a long, and I'm actually going to read the long. I like it. Sharon Toerek is a marketer and intellectual property attorney. Not often. Is this her first lawyer? 100% her first lawyer on the pod. An IP attorney who helps independent marketing, digital PR, and creative agencies protect their assets and turn ideas into revenue. She's the founder of Toerek Law, a law firm dedicated to marketing agencies where she focuses on IP, small contracts, and marketing regulation compliance. Sharon also hosts the Innovative Agency podcast and serves as a trusted legal partner to agencies and communities across the U.S. Sharon shows agency owners how to turn legal from a cost line into a strategic profit engine. She helps teams lock down IP rights, manage AI and data privacy risks, and negotiate agency-friendly contracts that protect margin and client relationships. In a very, very fast-changing market, she gives leaders clear, practical steps to stay creative, stay compliant, and grow. And as you can imagine, so we told Sharon this, right? We have agencies that listen to this. We have a lot of brand marketers, client side. This is going to be very applicable to you because today we are talking about AI and IP and all things data privacy. So this is going to be really cool, and this is great for our listeners because you guys get to hear our voice all the time, especially yours, Mr. Man.
Once in a while.
Today is Sharon's floor. So what we're going to do, Claudia, topic, por favor, if you could ring that bell. Sharon's going to walk us through, we're going to call it 2 risks and 5 tips. 2 legal risks with IP and data privacy, and then 5 tips for brand marketers and how you can overcome this in the years to come, especially given how fast it changes. So Sharon, over to you.
Amazing. Well, thank you for the floor. I appreciate it. We've been working pretty diligently over the last 2.5 years to identify what are the top risks that marketers, and whether you are a brand side marketer or you are in an agency helping brands navigate AI, we've seen patterns. That's one of the blessings of working in sort of a narrowly defined vertical. And so we see patterns in terms of risks that marketers face in incorporating AI into not only their operations, but particularly when using generative AI. And we've sort of developed some quick action strategies that probably everybody listening here can take away at least one of these and start working on them for incremental improvement in your risk management. Because my strong belief is that you got to balance the opportunities that we're all facing with AI, and I do believe strongly in those, along with some smart risk management, right? So that we're protecting ourselves along the way. So I would say that the top two areas of legal risk that marketers encounter right now in adopting AI is, first of all, intellectual property considerations, and second of all, data privacy concerns.
My goodness, yeah.
And, there are sub issues under each of those branches of the tree. But that's really what it comes down to in terms of marketers and their adoption of these tactics and these technologies. I've been an IP lawyer for a really long time before I even worked with marketers. And what I see out there now is a lot of sort of fear and trepidation around who's going to own the work when AI is used to create it, and who's going to be responsible if anything goes sideways in terms of infringing on other third party.
And Sharon, let's go back a couple of years to the whole Hollywood writer strike, right? I mean, it was that people were up in arms, et cetera. And I feel like that was kind of a big, I don't want to call it the catalyst, but it was a very newsworthy. And IP has always been, valuable and precious. But I feel like today I can't even imagine your world. I mean, seriously.
Right. It was a primary negotiating point in the SAG-AFTRA strikes. Both the writers and the performers were very concerned about, how AI was going to be used to basically cut into their potential revenue their ability to control their likenesses and their work over time. And then you've got the major owners of huge creative portfolios, the Disneys of the world, Associated Press, the New York Times, involved in major litigation with the major AI platforms. OpenAI was probably the first and most often sued, but Anthropic as well, in terms of ingesting in big, large groups, works that were owned by others without the permission of those people. And then it coming out in output when we would sort of use those engines to create as marketers. And so the question becomes, if you're a brand marketer, is how do I know that you, agency, are going to turn work over to us when you've used AI to create it and it's going to be ownable by you, by us, by anybody?
Dumb question coming in.
But no, I was just saying, and for our listeners, we told Sharon that she was going to just continuously blow our minds on this podcast. So please, there are no dumb questions.
Let's see if I can remember how to construct it. So this feels different. AI generating content is different than AI referencing content. Is that fair? Because it seems like Google has always kind of skirted this a little bit in showing images and videos of things that maybe they don't have access to. So a user can use Google as a reference, but AI taking it to the next step of generating content off that reference is really what this is about, right?
Right. Yeah, that's right.
That's very well phrased.
We're not really creating any new legal theories here under the copyright law. It's just that AI has created so much more real estate for infringement to occur. And
Good way to put it.
What we're facing is using it in the generative process of creativity, even conceptually and not in final assets, and the perceived cost savings in doing that, amongst brands and the agencies that serve them, means that you've got a lot of incentive to. I think this is changing a little bit, by the way. I'll sort of give a caveat to what I'm going to say, but potentially a lot of incentive to use these tools generatively to create work that leverages really highly, right? It's fast. It can be inexpensive. Of course, a copyright infringement claim is not inexpensive, but it can be inexpensive. It can be fast, and the quality of some of the work it's hard to argue with the utility of using some of these tools. But I think the difference, Roop, between what you used to be able to find or lift off of Google Images, for example, and what we're seeing now coming out of the major LLMs in terms of, creative writing or any of the platforms that create imagery, is that it's hard to know what's real and it's hard to know what's fake. And more to the point, it's hard to know if the output you're getting from these tools is identical to some
Bingo.
other owned work out there. You just cannot, there's no way for the user to really discern. And so you're taking risk without really the ability to do the due diligence to know what kind of risk you're taking on.
And that's on the IP side. And then we talk about data privacy, right? Oh my goodness.
Yeah.
That's
data privacy is, I think is under indexed in terms of concern level.
Yeah, I agree.
But, the one side of it is, as a brand, you collect data from lots of different places. This was always true. But, maybe somebody bought a list years ago. Maybe somebody went to a conference and got the attendee list, et cetera, et cetera. You're glomming all this information together, turning it over to maybe an agency, maybe a vendor partner. Like I said, the real estate for breaching a data privacy rule has gotten more and more vast because the ability of these platforms to manipulate this data and use it is just exponential. And so I think AI-enabled and unintentional data privacy violations are going to be a frontier of risk for marketers generally. And so if you're running campaigns, using data that or agentically using this data, especially, that concerns me quite a bit.
Oh my God. I didn't even think about the agentically side, but at 100%. Well, and we're not even, we as Littlefield agency, we're not in a highly regulated, we don't have healthcare clients. And I mean, I can't even imagine in the super highly regulated space what that looks like as we get into data privacy. So again,
I know. And I've just been absorbing some content recently, some legal content around the inferences that can be made by AI when they put data points together from unrelated sources about somebody's personal health information, personal financial information. It's really frightening. I mean, from a marketer's perspective, what can be done with that information intentionally, unintentionally. Yes. And it's, it's not the job of the marketer to be the lawyer in the room, but it is the job of the marketer in the room to risk spot, right? And
that's well said.
The person in the room brave enough to say, you know what, we need to slow this down. And marketers don't like to slow things down, as you all know. They like to move fast. They like to be viral. They like to
go.
Strike while iron's hot. And so kind of looking at around that corner and being the person in the room who says, wait a minute, let's think about this more.
Yeah, this is probably a great podcast for you to listen to. You're describing Roop, by the way, who deals with a lot of our data.
Completely above the line on the wall. I just want everyone out there to know that.
But Sharon's point, and you hit the nail on the head, I think it's the unintentionality, right? None of us are trying to get sued or have our clients get sued, but yes, we got to move fast. Oh God, we didn't think that's the risk spot is very spot on. So as we think about not only agencies, but our clients, right? Our clients and our prospective clients that are listening to this on the brand side, Sharon, as we're on it's not the forefront, but as we're navigating this ever-changing landscape, and who knows what we're talking about in 12 to 24 months, what are your tips I like the risk spot idea, but we got to move fast, we got to act, we got to convert leads, we got to make more money. So for those brand marketers, as they're looking to increase revenue, what can we be doing, and then how can we help as agency partners as they navigate this?
I think the first thing to remember is this is a team sport. And so if you're a brand marketer, I'm going to say the first tactical takeaway I'd love for you all to have, whether you are in-house at a brand or whether you are on the agency side of things, first step, it's crucial conversations. Okay. If you are an in-house marketer, that means you need to be having those conversations with your IT people, with your internal legal people, sometimes even your procurement people as marketers, so that so everybody's on the same page about what your company's policy is around using some of these platforms, what kind of due diligence is done, what are the human guardrails around all of this. Likewise, going across the bridge, if you will, you need to be talking to your agencies, your vendors, and agencies listening. You need to be talking to all the right constituents on the brand side to understand what are your policies around AI usage, what use cases are okay, what use cases are not, what platforms are okay, etc. So crucial conversations, that is the first risk management tool I want you all to keep in mind, because that is what helps you all surface the risk and plan a little bit more carefully for it.
Well said. Okay.
All right. Step 2, policies. And I know many of you listening would rather watch paint dry than think about writing a policy.
You love our policies, don't you?
I've watched the paint dry.
You've been here for 15 years. You ever read an employee policy here?
I have a whole employee handbook I've never opened.
There you go, 15 years later. But thank you, Sharon. Please, let's enlighten them.
We're going to change that. We're going to change that dynamic. And the goal here is not length or complexity. And that can always become the end goal. But I want you to start, today, tomorrow, Monday, whenever. Think about what your organization's policies need to be around AI usage. Checklist it first. The platforms, the use cases, the permissions, the human guardrails. And don't just write the policies, but socialize the policies with the people who need to know what they are. Have an internal policy, have an external facing policy, so that the rest of the world with which you deal on a regular basis, vendors, partners, suppliers, understands where you're coming from, and vice versa. So that's step through. And that is something anybody can get a good start on, with or without legal intervention, at any time. Just think it through from a business perspective. When it's time to get legal to weigh in, then have them weigh in once you've got a good foundation going, right?
Well, and I think about our AI policy. I think our AI policy is changing every 45 to 60 days, truly. Julie just sent out an email.
Perfectly normal and healthy, and it's going to be a dynamic, living, breathing document, because AI is moving faster than any other technological force we've had foisted upon us as marketers. Honestly.
And now that you say this, I don't know. I need to look into. Just wrote myself what to do. So thank you, Sharon. Is the external policy like what? How do we communicate this?
If you're an agency, having a client-facing policy is a really smart client management and risk management tool.
Okay, thank 100%. You. All right, number 3, Sharon. This is great.
Step 3, contract language. If you're a brand, and you want to be thinking about how you are expressing your rules, your expectations, and obligations around AI usage in your actual service agreements with your vendors, your partners, and the like. Similarly, if you're a vendor, you're an agency, you want to have relevant language in your agreements with your clients, with your third-party vendors, your data brokers, all of those folks, around AI usage, so that everybody understands. And these have to waterfall with each other, right? The brand to agency contract should waterfall with the agency to vendor contract in terms of who is responsible for what and where the liability might lie if anything goes sideways. So good contract language.
Great point.
Around all this. Fourth, that's another watching paint dry tip for you all, but I want you to take a look at the terms and conditions of at least the top 3 LLMs that you are regularly using on a day-to-day basis. I want you to make sure that you understand what they say about IP ownership.
That
you understand what they say about liability, indemnification, all that fun legal stuff. And I want you to understand what level of subscription you have to the various platforms you're using. In today's modern marketing world, whether you're a brand marketer or whether you're an agency marketer, you're using freelancers sometimes or all the time. And you need to make sure that they understand the terms and conditions of all the platforms that are being used, and that everybody's using the same enterprise level account or professional level account, and you've got the right level of security for you and your uses. So evaluate your terms and conditions.
So Sharon, you're telling us is before you go to bed, or maybe it's just part of your work, you're reading T's and C's of LLMs.
Look, I mean, let's take it slow, right? I mean, maybe we have a lunch and learn.
There we go. Yeah, right. Okay. Hey, lunch.
Margaritas
10.
and beers, and we put the terms and conditions up on a screen, and we look at it together. I don't know, whatever works for
Okay.
you, or,
Okay.
maybe you divide and conquer. Like I said, this is a team sport. This is
Yes.
not just the job of any one person, and I didn't say read them all, Sam. I said you start with.
It's good for you, buddy.
Is there an audiobook version?
Yes, there's an audiobook version.
Right, audiobook. I love it. If you don't understand something, that's how you know to ask questions.
That's fair. That's fair. Okay, no, I'm aligned. Number 5, Sharon, lay us on us with the last one here.
Sort of relates to the last with team training. It does you no good to write policies. It does you no good to update your contract language or read the T's and C's of the platforms you use if you are not regularly socializing this information within your marketing department, across departments, if you are in a mid-market or enterprise-sized company, with your agencies, or internally in an agency. Regular team learning, training, conversations around all this to make sure that you are as up to date and as able to spot issues as possible.
So here's the thing, and we were going to throw you a bonus question, which we are. But these 5 tips. I mean, this is great. Like literally, as we're jotting down notes here. Do you have anything to add on to that?
No, I'm just trying to stay out of jail.
That's a good tip. There's tip number 6. Stay out of jail. Okay, bonus question, Sharon.
My cell phone number for starters?
Yeah, we'll talk after the
That's
Zoom.
exactly. We won't share that publicly, but thank you in advance. Sharon, 5 years from now, biggest AI legal mistake that a company will look back and be like, man, we should have addressed this sooner. And you just gave us 5 great tips. But like, if there's one big thing that a brand marketer and they're like, damn, should have done that. What is it?
I think it's going to be around misuse of data. I really do. I think we're going to figure out the IP stuff a lot sooner than we're going to figure out the data stuff. And the reason for that is that there is no uniform standard in the United States around data privacy. And I'm not optimistic there'll be a uniform national standard around AI and liability and things like that for misusing data. So I think it will have been a breach of somebody's data privacy rights caused by the use of one of these platforms.
I think you were spot on. And the analogy that comes to mind, Sharon, is think about, and cryptocurrency is still a thing, but like think about the literal United States federal government trying to figure out crypto years ago and the regulatory components of that. And I do think about this, like they are trying to figure this out. And I know that Altman and all those guys they're in court and they're having all the high level conversations, but it is crazy to me, given how fast this is moving, how it is regulated and how they do keep up with this, because so far I just feel like it's crazy.
Well, we're seeing parallels, not to get too deep into it policy-wise, but there's parallels between the way we've handled data privacy lawmaking and the way it seems like we're looking at AI lawmaking in the U.S. right now. We've got this state-to-state patchwork of data privacy rules, no federal standard, and really no positive movement that's meaningful towards a federal standard. You have that with AI too, but you have the additional layering on top of it of the federal government right now, anyway, as we're having this conversation, doesn't really want states to get involved in regulating AI. They took a hands-off approach regarding data privacy, but they really would prefer the states do next to nothing in terms of regulating it. So we'll see what happens.
God, it's good. Well, we got saddle up, everyone, then fasten your seatbelt because we're along for the ride. Sharon, this is great. This was very, very insightful. Like I said, you're our first legal representative to ever be on the podcast. So that this is wonderful and very insightful. And to our listeners, right? If your agency side, awesome. You probably know Sharon's name. She's very well respected and known in our industry. If you are a brand side marketer, have not heard of her, check out her podcast, Innovative Agency Podcast. Lots of insights to continue to be gathered there. But Sharon, we know you're a busy person. You're fresh out of Los Angeles for Small Agency of the Year. So we are just so thankful that you joined us here virtually today.
It was a delight talking with you guys. Thank you so much for having me on the show. I really appreciate it.
Absolutely. This will go live here soon. We'll keep you posted. We'll tag you. And we look forward to staying in touch when I bump into you at the next conference and hopefully not spill your coffee this time.
Amazing. Let's do it.
Okay, Sharon, thank you so much. Great to see you as always.
Bye, guys.
All right, bye-bye.
Adios.
And that's a wrap. We hope you found a spark of inspiration for your marketing strategy. Don't forget to subscribe and follow us at Littlefield Agency to keep the conversation going. Catch you next time.